We're going to turn our attention now to the state of California and a preliminary hearing in the fugitive ex-Marine murder trial. The defendant here is a guy by the name of Raymond R.J. McLeod. He's accused of killing his girlfriend, Krystal Mitchell, in a drunken rage back in San Diego in 2016, and then fleeing to South America. He was on the run for 6 years before he was captured teaching English in El Salvador. The victim here, 30-year-old single mother Krystal Mitchell, was found beaten and strangled in an apartment in San Diego. Court TV crime and justice correspondent Matt Johnson has a look at the case against McLeod.
I remember that night when I got that phone call. I mean, this is, I've been on the side where I had to give the message to parents. Sometimes I didn't want to give the message that the child has been murdered, and I'm on this side.
The day her daughter was murdered was the day former police detective Josephine Wenzel came out of retirement. On June 10, 2016, 30-year-old Krystal Mitchell was found dead in a San Diego apartment. Krystal was in town visiting friends and traveling with a man that she recently met, a former Marine named Raymond R.J. McLeod.
There was nothing to alert her that he was a terrible person.
What Krystal did not know is that McLeod had a disturbing history of violence against women. On June 10, 2016, the pair was drinking at a local bar, where a bystander witnessed McLeod slap Krystal. Shortly after, McLeod is captured on surveillance video, putting his hands around Krystal's neck and guiding her into the apartment, where her body would be discovered later that day.
This strangulation was so violent that there were 3 separate fractures to her voice box. McLeod then took her car, he parked it at the airport, rented a car, and went to Mexico. He fled.
A manhunt that would span 6 years and several countries.
I tracked down the hostel he was at in Livingston, Guatemala, but I was a couple weeks too late. By the time I got there, he was gone.
Then authorities got the tip they needed. The ex-Marine was in El Salvador teaching English.
I was just crying my eyes out, like, we did it, we did it.
Raymond McLeod was extradited back to San Diego. He has pleaded not guilty. His attorney claims Krystal Mitchell died accidentally during rough consensual sex with him. McLeod faces 25 years to life if convicted.
Okay, that's the setup. Let's go in now to this preliminary hearing out in California. And California is one of those states where a prelim is pretty juicy. I mean, you find out particulars in a case, and that's what we're going to do right here. This took place during the suitcase murder case for Sarah Boone, so we recorded it and kept it just for this reason. So let's go in, and we're going to start with the defense argument here. It's a presentation basically of an affirmative defense that they are going to be presenting, that this was, yes, homicide, but it was an accident.
The defense intends to introduce statements from declarants that were interviewed by the police pursuant to Penal Code Section 872B, who each has personal knowledge of the case and statements from the declarants because they personally interviewed the declarants. That's from Whitman versus Superior Court. Cite again, 1991, 54, Cal 3rd, 1063. These statements are expected to include interviews conducted by the investigating officers in the case, in which a number of women explain in detail the type of sexual activity that Mr. McLeod regularly engaged in with them. Specifically, they made statements about spanking, whipping, anal sex, other rough sexual practices, including the use of foreign objects, and most importantly, their regular experience with consensual erotic asphyxiation. If Mr. McLeod regularly engaged in erotic asphyxiation countless times with large numbers of women, including previously with the decedent, then the circumstances of her death are consistent with the exact same behavior, then those statements from the declarants are both permissible hearsay pursuant to Penal Code 872B, are admissible evidence for purposes of preliminary hearing pursuant to Jennings versus Superior Court, 1967, 66 Cal 2nd at 867 for purposes of raising an affirmative defense. The expected cross-examination of these officers is not intended for discovery purposes, as the reports are quite thorough. The cross-examination will be limited to establishing the prior conduct of Mr. McLeod and Ms. Mitchell as it relates to consensual sexual activities, both with prior sexual partners and with each other, to demonstrate consistency with the circumstances surrounding Ms. Mitchell's death.
The problem with a lot of these statements is that they're voluminous in the sense that bringing in a character witness to talk about the facts of their circumstances, sex-related or not, is limited. We're talking about relationships that they had going back and forth, which is consistently different than what the facts are in this particular case. So when we start to open the door to all these declarants coming in, it's going to be voluminous in that back and forth. I can start with the first one, J.H., and I guess I can categorize them as defensive, which would be the first and foremost, which are those female declarants that I believe are being brought in as character evidence to prove the defendant's intent. All of those at this point in time should be limited to they themselves have had a sexual relationship with the defendant. However, none of those declarants have any personal knowledge about what actually occurred on June 10th of 2016, which is where the problem is. There is no link. Yes, all of these witnesses, all of these prior spouses, all of these prior girlfriends, all of these prior hookups, whatever they would like to call them, may have an established relationship with the defendant. However, simply because they have an established sexual relationship with the defendant does not mean that they get to come in and say, this happened, so this must have happened on June 10th without any other link. And at this point in time, I don't believe there's been any offer of proof for that link. There is no evidence with regards to that is what happened based on any statements. There were two people in that room based on the evidence that we have and that we know. One of those person is here and the other one is not. Allowing in all of those declarant statements then opens the door without actually putting forth the evidence forth to then swing it open. So I can go through all of those statements to sort of articulate why I believe each of these declarants should be limited, why they should be limited, and then go through the secondary ones, which are those related to the victim in this case. And then lastly, which I don't believe defense counsel has stressed, which would be potential expert statements based on that, all encompassing the affirmative defense. But I first want to say that link up why it matters and why it's relevant at this point in time that these women have a relationship, consensual or non-consensual, with the defendant, how that plays a role in what happened on June 10th, 2016, which is the focus of the preliminary hearing.
All right, need a break here. That you just heard the defense and then the state refuting that plea from the defense to go with this affirmative defense. We'll see what the judge says when we return in the fugitive ex-Marine murder trial. One of the expert witnesses in this, Dr. Drew, he's going to take the stand as well. So stay with us. Welcome back to Court TV Live. I'm Ted Rollins. Glad to have you along with us on this Tuesday. We have been watching a preliminary hearing out of the state of California in the fugitive ex-Marine murder trial for Raymond R.J. McLeod. He's accused of killing his girlfriend, Krystal Mitchell, back in 2016 and then fleeing to Central America. We just heard arguments from the defense about presenting an affirmative defense that was a homicide, but a homicide by accident. Let's go back into the courtroom now and get the judge's decision.
I see in this case, with respect to the proffered evidence, that the defense is seeking to present to the court character evidence under Evidence Code Section 1102 of the defendant's character or trait that is material to the underlying facts and circumstances of this homicide. However, the defendant's proffer of his character trait for a specific type of sexual behavior is not unlimited in the sense that the court also needs to determine whether or not under Evidence Code Section 352 the evidence is relevant and the probative value is not substantially outweighed by an undue consumption of time, danger of undue prejudice, confusing the issues, or misleading the court. It is also not a blanket admissibility under the character evidence statutes. It must be non-hearsay, it must be a percipient witness, and relevant under Evidence Code Section 352.
Moments from a preliminary hearing in a case against defendant Raymond McLeod. He's a former Marine accused of brutally murdering his girlfriend and fleeing the country. We're going to pick it up now with testimony from Justin Seydell. He's a friend of McLeod's who McLeod and victim Krystal Mitchell were visiting and staying with on the night that she died. Take a listen.
When you left the house, had you seen the defendant or Krystal?
No.
Had you heard the defendant or Krystal?
No.
Did you attempt to contact them at that point?
I don't believe that I attempted to contact them before I left. It was maybe 9 o'clock in the morning, which is not early, but if you're out drinking, that can be kind of an earlier time. So I don't recall talking with them or messaging them or anything to that effect that morning.
When you left the house to go play volleyball and then go to your school project somewhere and coming home to the apartment, had you had any communication with the defendant?
No.
Or with Krystal?
No.
What happened when you arrived home?
Arrived home late, early afternoon, I would say, maybe between 12 and 1 o'clock. That's a guess on the time. There was no one out, no sound of any kind. I figured they were either still sleeping or the vehicle was there, I believe, so I didn't think that they had left. So I thought that they were probably still in the bedroom.
At that point, what did you decide to do?
Knocked on the door to the bedroom, and I didn't hear anything. I imagine I would have probably knocked several times and not getting a response. I don't remember this for sure, but I'm imagining at that point I would have maybe cracked the door and said hello or something, and still didn't hear anything.
You say you don't remember for sure. Are you saying it's difficult to remember step-by-step details about the idea of knocking and opening the door?
Yes, ma'am, exactly right.
But is it fair to say that you remember knocking and then at some point opening the door?
Yes, absolutely.
Okay, thank you. What happened when you opened the door?
I opened the door and I saw Krystal in on the left side of the bed. She was mostly covered with a sheet, and she had one of her arms up in a kind of an awkward position for someone who would have been sleeping almost straight up in what seemed to be a very unnatural position for someone who was sleeping.
Let me stop you right there. When you say straight up, do you mean in the air, resting on the bed? Can you sort of give us a better description of what you're seeing as you walk in?
Yes, laying on the bed, but the arm was neither laying on the bed nor on the pillow nor resting comfortably on her body. It was up at maybe a 45-degree angle, again in an awkward position for someone who was sleeping. It became clear to me very quickly that she was deceased.
You testified earlier that you slept throughout the entire night. Is that correct?
Yes.
Okay. You did not hear any yelling that night?
I did not.
You did not hear any screaming that night?
No.
You did not hear any kind of physical altercation that night?
No.
And I am assuming that because you have training and you served as a Marine, you're familiar with combat and you're keenly aware of what fighting looks like and what it sounds like. Am I right?
Yes.
Okay, and you're also an EMT. But on that night, you told the police specifically that you didn't hear a thing. Is that correct?
That is correct.
And you didn't notice a thing. Is that correct?
Correct.
If you would have heard screaming, would you have gone into that room and checked?
Absolutely.
If you had heard yelling, would you have gone into that room and checked?
Objection, relevance.
I'll allow the answer. Go ahead, sir.
Yes. In duty in Phoenix, Arizona, Raymond was a potential Marine. We called them poolies. He was a poolie under one of the other recruiters in my office, so that was the first time that I'd met him.
Okay. And so at some point you were both Marines together, is that correct?
Correct. We never served in the same unit, but we were in the Marine Corps at the same time, yes.
And is it your understanding, based on your personal knowledge, that Mr. McLeod served several tours of duty as a Marine?
Objection, relevance.
Overruled if you have personal knowledge.
I know that he deployed overseas. I do not know where specifically or to what locations.
Do you have personal knowledge if Mr. McLeod left the Marine Corps in 2007?
I do not know the exact date.
Do you have personal knowledge whether or not he was honorably discharged?
Objection, relevance.
Overruled.
I do not know the status of his discharge.
Do you remember telling the officers that day that R.J. McLeod may have been suffering from PTSD?
I do not remember telling them that, no.
Again, you would have been truthful with the police when you were questioned that day?
Yes.
And so if there is a report that says that you believe that he may have been suffering from PTSD, that would have been an accurate statement based on what you remember that day?
Yes.
Thank you. When did you leave the Marine Corps?
Separated from active duty in 2010 and out of the reserves in 2012.
But after you left and after Mr. McLeod left the Marine Corps, you kept in touch with him, correct?
Yes.
And you would communicate with him about once a month or so?
Sometimes it would be months between contacts. Sometimes if there was a plan to be in my city or in I was taking a trip to Phoenix, we might communicate more often than that. But typically once a month, once every few months, I would say we would exchange some correspondence on social media, typically on Facebook, I believe.
And you visited each other occasionally?
Yes, maybe 3 to 4 times that we would see each other, either when he would come to San Diego or on a few trips that I had made out to Phoenix.
And at one point, when you met with him, he was married to a woman named Rachel, is that correct?
Yes.
And you met Rachel?
Yes.
And you spent time with her?
Yes.
And you remember describing Rachel to the police as an alcoholic?
It sure seemed that way to me.
And as an out-of-work stripper?
Yes.
And as a dumpster fire?
Relevance?
Sustained at this point.
So you would visit with RJ a couple times a year. And in the week leading up to this incident, which was June 9th, I believe, do you remember if it was June 9th or June 10th?
I do not remember.
Okay, so in the week leading up to this visit, do you remember speaking to Mr. McLeod about him coming up to San Diego to have some fun with you and for you to meet his new girlfriend named Krystal?
I do not remember, but that is consistent with what ended up happening. So I would imagine we would have had correspondence about it before then.
And you agreed to have them stay with you?
Yes.
And from your recollection, do you remember seeming excited having Raymond seem excited about this new relationship and you meeting her?
I don't know. We don't discuss those things and never really have in that manner.
If you spoke to the police after this incident and you were truthful with them?
Yes.
If you would have told the police that Mr. McLeod seemed excited about her coming and you meeting her, would that be an accurate statement at the time?
If that's the statement that I made, then yes.
Okay, thank you.
All right, let's bring back Marie Pereira. Marie, this is a disturbing case, to say the least. There is, video of the two in an elevator before her death where he's got his hands on her neck. The affirmative defense that they want to put on is that this was a consensual sexual session where it was consensually, I guess, violent, and she ended up dead. And then, of course, he runs away. Does this fly, do you think, this defense in this case?
I think it could fly, and I think we have a lot more to ascertain on both sides to see what their theories of the case are. And I think this prelim is putting a lot of light on everything that happened. But it is kind of weird that after the incident, he immediately fled. And that is what we call consciousness of guilt. If you did nothing wrong and you had a plausible explanation as to how she ended up dead, then why didn't you try to call 911, turn yourself in, and explain the situation? People who run away usually have something to hide, so that is going to work against him. I was listening to the arguments on both sides earlier, and, they want to put on an affirmative defense, but one side wants to limit what can actually be used. They don't want to use character evidence, other women that had contact with him, his history of loving rough sex and things like that, but at the same time, they want to use it, the defense. You have to choose what you want to use, because at the end of the day, character evidence is not a good thing, because you don't want to show that someone has a propensity to do anything and prejudice them. But they say also, if someone shows you who they are the first time, listen to it. If he's a violent person and he has a history of violence, sexual violence in his relationships, somehow the judge is going to have to balance that out to see what's going in and what's not.
Yeah, let's listen to more of this testimony. We have to get to a break, but the next one we're going to listen to is, to your point, Marie, someone else who was in a relationship, actually a girlfriend of the last witness, so someone who may have understood some more about this defendant and his relationship with his girlfriend.